Thank you very much, Mr. Senabulia. I want to ask you all to tell us a way forward whereby there is a limited space. I'm now talking about on the issue of hearings on the ECMES, because now I know election petitions are bulky in terms of typing proceedings, and on the ECMES we have a limited space for typing the proceedings. Why don't you create enough space now for typing the proceedings? Because the judicial office has of recent, they first type in Word and then transfer on the ECMES, because it has limited space. So what are you going to do about it?
Yes, Worship Lubowa, Doctor.
Yes, thank you so much, Mr. Sinabulia. The issue I have is about the taboo scribe. To what extent should we fear, especially in the existing politically excited environment, for the artificial intelligence to capture satanic verses, which can cause, there is a court somewhere where one of the parties is contesting what the judge wrote, saying that is not exactly what took place. I just fear that the AI can capture some strange statements which can even aggravate the situation. Just to comment about, you commented about it, but specifically now I'm talking about where we trust the entire transcription to AI. Thank you very much.
Thank you, Doctor. Doctor speaks into data privacy and protection privacy issues. We have Dr. Gladys here, then we'll revert back. Yes, Dr. Gladys, you can share with your sister the mic.
Now, about AI, I'm a researcher and I use it a lot. I have so many applications, but you must be cautious. AI is data in, data out, garbage in, garbage out. So even if it's a transcription, you have a duty to go through it. I've written so many articles, but somewhere you find it's even quoting a case, say Ara versus Nixon, and then it says something very different. Because for it, you have fed in the information and has already captured the theme. So if the theme is about, say, unlawful illegal activities, it will frame a sentence around illegal activities so that the sentence or the paragraph flows properly. So now it will even quote a case. That's AI, it's like a robot, because you have fed into it and has picked the signals of where you are going. So it's very, 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 very important to cross-check, especially the references that are accompanying sentences. Because in most cases, I'm sorry to say it, but you'll find that they don't really exist, or the case doesn't exist, but has captured different data online, or from theses, or from papers, or from blog pages. It picks a lot. Then it fits it into your theme to satisfy you as its client. So AI never fails you. At least that's what I know. It never fails you. It must have an answer for you. So always cross-check. Coming to transcribing, please cross-check. Judgments, please cross-check. Document summary, please cross-check. I'm speaking from experience. Thank you.
Thank you, Doctor. My sister, Worship Lillian.
Thank you, Session Chair. Mine is regarding the digital stamps and seals, and the fact that some of us, because of the volume of work, tend to delegate some of the ECMES-related work. I want to ask if, even if the seal is in my account, whether it is transferable. If I delegated a judicial officer to handle that work for me for that time, would they be able to transfer that seal? And it is related to the integrity of the system and the possibility of the seal being used in a document other than it was intended.
Thank you.
The other is, as petitions get filed, we might find a situation where a judge is coming from an EKIMIS court to a non-EKIMIS court and vice versa. So what advice would you give to the registrars to be able to facilitate their judges to navigate that transition? And when is filing, and I'm asking this conscious of the time constraints that come with the election petitions, at what point is a file effectively said to be registered? Is it at the point of upload, or is it at the point of a registrar endorsing their signature on that document? Thank you.
Thank you so much, Your Worship Lillian. Can he first answer this set, then we come for set 2?
Thank you very much, Your Worships, for those questions. Let me begin with the first one, which was talking about the space that we have. Now, in as far as the EKIMIS file is concerned, we have particular cards that store information on it. Now, there is what we call a notes card on EKIMIS, where majority of you type your proceedings. That notes card is restricted in terms of characters. We began with around 500 characters. Now we increased it to 1,000, and people have always been asking us to increase the number of characters permitted under this notes card here. So under the notes card, we also provide you with an option to upload, because the notes were designed to be very few notes that summarize whatever happened in that court. But now if it gets to proceedings that take more than 5 pages, they will definitely not fit in the notes card. Now those will have exceeded being notes. Those will now be proceedings. So under the same section on the notes card, there is where we allow you to upload. So if you know your proceedings are going to exceed 1,000 characters, which the system permits in terms of notes, then you have to create a Word document and be able to upload it under the notes card, so that we can be able to have it there. If not, then you can upload it under the court sittings. There is also a section where we put court documents. If you don't want, because I know that some of you do not want the parties to look at your proceedings, the type proceedings, or whatever you are putting in the notes card. That's why I said there is the other option that can make them confidential and then allow you yourself to only be the person that will view those notes or the proceedings in that particular sitting. So that's the option that we provide for you under that. Then the other one in regards to the security of the TurboScribe, yes, we as IT people are actually not in control of these web-based applications that I've been sharing with you. They are under cloud computing. Whatever you upload there is in the cloud, and I'm not in charge of the cloud. So whether it's an audio file, whether it's a written document, I'm not in charge of the cloud. That if it's a Google cloud provided under Google, where we have Gemini as a search tool, you will find it there on the Google cloud. If it is the Microsoft one, then you under Copilot, you will find under the Microsoft cloud. Most of you are actually required to create accounts in order to access them, or log in using your Gmail account. So whatever I have under my profile, I request the person to be sharing my screen, because whatever happens under my profile is stored under my account, the Gmail account. So the documents that I upload, since I'm logged in using my Gmail account, they are stored under my Gmail account. The other people might not view them. So that's the only security it provides you, that they are stored under your Gmail account. The other people won't access the recordings under your account, because you are required to log in using that account. These ones that are free and open, where you do not log in using the account, so those ones that are not stored under my account, So all these documents, I'm logged in using my Gmail. When you look at my account at the top there, it is my Gmail account that is logged in TurboScribe. So even you will be expected to log in using your Gmail account. So that's the security. It stores them under your profile in your Gmail account using this. Except those ones that are open and free of charge. That's why it even becomes very hard for these other sites where you collect information to dig into your Gmail account if you have ever uploaded a document there and access it and use it as a point of reference. It's only open sites that allow you to access, that allows this AI to access the information that you've posted on these open sites. So that's the only confidence I can give you under this. So the same applies to the other website. If it is DeepSeek, you still log in using your account, but these ones that do research collect information from various sources. Some of them even ask you to upload like 5 documents so that they can give you open access. So you upload any 5 documents from your computer, then it gives you open access to access other people's documents. So some of them are not secure. They avail that information online to the other. So you have to be very cautious, especially if you are using them. Then the last one, the last ones were in regards to the court seal and stamp. I think this is a very sensitive issue, even when we are coming up with these stamps, because most times you have to sign these documents, and the implementation we are guided by the technical committee to do is to put it in your account. You as a registrar, to be responsible, because it comes with your signature. It also gives you access to the stamp, so it will be like you are giving away your signature to the clerk, the stamp and the seal to do the work for you, to appear as if she's the one who signed, stamped and sealed those documents. So it's a bit very sensitive if you are to put it in the clerk's account, or else the clerk will have the stamp, then return the document to you for signature, which will also be a tedious process. So we have to be very careful if we are giving out some of these stamps and seals to be available to the other staff. Unless if they are going to work under your account and under your strict supervision, that the person sits in your chambers and is there doing the work for you under your account. But we are restricted to giving them these stamps and seals into their accounts. Otherwise, you will find so many documents being issued out and served which are not being issued by you or signed by you. Then, the time of filing. Now, like we've seen the process here, it is at the point of registration and giving a number, as per your rules, that the file is registered in court. So the moment these parties get this file number, the number is what confirms the registration. And now the number is being given out by the system. The best we do is to implement rules that restrict on particular documents that are required to be filed so that they are filed in the system. If it's a civil suit, we expect a plain to be filed. If it's a miscellaneous application, we expect the notice of motion or chamber summons to be filed. So we only put those restrictions and tell it, please check if a person is filing a civil suit and it doesn't have a plaint on it, don't accept him to register and get a number. So it doesn't permit to register. So those are the only restrictions that we put. But at the point, the registration happens at the point where the file is registered in the system and it's given this file number. So the other one will be admitting the documents. We allow you the chance to be able to admit after reading and comparing with what the rules are telling you within the system. If you are to decline as per the rules, the authority is left. We don't want the system to do for you that. We want the authority to remain with you. If you want to decline a document or dismiss a document or dismiss a file, otherwise the system would have been locking out. If you realize 30 days you are supposed to file an election petition, it counts from the time of declaration of results. On the 30th day at midnight, it closes. No more election petitions to be filed. But that is something that is open to you. If you want us to implement it in the system like that, we can also implement it. We just tell it the date of declaration of result and tell it count 30 days from the date of declaration of results. Then as other people are filing after midnight, it locks them out. So we can do that as long as you agree and it comes as a recommendation from this forum. I think those were the questions. Thank you very much for listening.
Thank you so much, Mr. Senabuja. We are going to take another set of questions. We shall start with His Worship Chintuzi Ntusa.
Why should we have cases filed when they have not paid fees and they remain and clog the system? For how long should they remain in the system? Thirdly, I think you answered that. Who can access the recording that we have uploaded on ICMIS? That is restricted, I think. Then on the issue of notices, if the rules and the law provides you should reply to the petition within 3 days, why is the notice coming out blank? The notice should come out with the number of days you are supposed to file to reply to the petition. The rule is clear, 3 days, so don't leave it blank. Let the notice on the system be imprinted with the number of days you are supposed to reply. We are talking with His Worship Faisal, otherwise some of our marriages may die. We are on ECMIS all the time. So try to make sure that you help us to, if the law is clear on what should be done, then don't tell me again I have to type there what the law already provides. You let the form be it is clear that you should file a petition within 3 days. Don't give me more work, Mr. Senabuja. Then, yes, then you said what English? I saw American English. The system translates American English. Are we using American English or the British English? Then can't my laptop do the recording rather than, if the laptop can do everything and I'm on ECMIS direct, can't it do the recording? Should I get a recorder for that purpose? And then lastly, can the system provide, you didn't tell us how we can get statistics on the cases that have been filed on maybe election petition, which period, maybe you can demonstrate. Thank you.
Thank you so much, Your Worship. Colleagues, I am moderating. I'll be going to Catherine Aguero, but allow me to just put a question that speaks into what he said. Mr. Senabuja, from the demonstration you've given us here, the summon to answer petition in the system is the summon for divorce. You haven't yet updated the system to put in a summon to answer petition in an election dispute. So we would want you to revise that. Secondly, the amount of money you've selected that the system allows for the petition, put in fees for a petition in an election dispute, which is 150 and not 60, not 6,000. The 6,000 you've selected and you kept on checking it was not giving you the 150. The money there that you've configured is for letters of administration. So is the petition, the answer to the petition there, the notice. The notice you've, after the other conversation, you put in the one for letters of administration. Put in the one for election disputes. Now, I would also want to inquire from you. You have said that, maybe let me state that maybe it might come from the gallery. Let's go back to Her Worship Catherine Aguero.
Thank you very much, Mr. Senabuja. Going back to what His Worship Chintu submitted on all the question he asked, what are we supposed to do with the cases that are filed without pleadings being uploaded? And then also we have those who multi-file. They will file one case like 10 times. What are we supposed to do as registrars?
Thank you. Our rep from Mubende.
Yeah, thank you so much, Mr. Senabuja. I want to comment on the last bit you concluded with, that the system can be agreed and the system automatically closes at midnight. I want you, while considering that, also consider whether you can work on the other areas also where the law says maybe a suit, if you don't take action after 28 days shall abate. I don't know whether you can also consider that, so that we are not seen as enemies. Want the system to take action because the law already says it.
Thank you so much.
I was a bit hesitant to ask, but maybe I can. It's still about pleadings, because sometimes you find that there is something which is a semblance of pleadings, but it's actually not pleadings. And I was wondering whether the system is able to, whether there is a baseline for what a pleading is in the system, so that not anything is just flashed on the card of pleadings and we take it as pleadings. Because otherwise people are just filing in anything in the system and we are registering it as a case. Remember again the issue of cases being filed without pleadings and they are getting numbers. That is extra work. That eventually becomes backlog. So every rubbish is getting into our system and we are registering them, giving them numbers as pleadings. And then again, emphasis on the issue of fees. Why is it that cases are getting registered without paying fees? And we are working retrospectively. I think that should be sorted out.
Yes, we go to Tororo, Our Worship Edim.
Yes.
Thank you, Your Worship Arum.
Yes, thank you, Worship Faisal. Thank you, Mr. Senabulia. I'm just emphasizing on the issue of court fees. I had a scenario where they registered, the fees were not paid, and that is the manual system. So I refused to sign until the fee was paid. And the lawyer dodged like almost 6 months. So the file could not move until he paid. And that's when I signed. But again, when it reached to his lordship, to him, he took it as though it was a smuggled something, and he had to call for a meeting. Why? The case was registered and then signed after all that. So it's just emphasis that the issue of fees should come earlier than registration.
I think JTI will have to print for us a list of the fees payable in election disputes. And we take that list as we leave today, so that it is also given to Senablia to enable him to configure it into the system. Mr. Senablia, I now invite you to... Oh, there's another hand? Oh, sorry, my brother. Okay, we shall start with the Ntebe, then go to Mbale. Her Worship Rashida first.
My concern is that the use of ECMIS at one point generated audit queries that involved the work of registrars and some judges, specifically arising from court fees. Can we know what it entailed and what is there for registrars to avoid or watch out for? Thank you.
Now we go to Mbale.
Previously, we've had the directions like the one which came to their lordships. All cases registered, transfer them to civil division. All election petitions, transfer them to civil division. And indeed, when it comes to hearing, the judges are switched for political reasons, especially for our judges who work with us in the circuits. Now, we are here trying to allocate them, judges, who will not, in fact, hear them. And two, since this is a special assignment, can we engage the Law Society that register all your petitions in the civil division, if you can? whether they are from Kabale or Mbale, ABC, register them in the civil division if you can. The headquarters will allocate them, but they will be tried in the circuits. Alternatively, can we receive them and we don't allocate them, since it will be within a very short time? We shall begin receiving them around after 20th January. Then the hearings will begin around 20th February. Can we receive them? We don't allocate them, we send them to headquarters. Then headquarters will send us the trial officers. Then the next question, it seems not to be yours. I wanted to talk about the jurisdiction of registrars in election petitions, but let me reserve it for the two generals who will be coming in the afternoon. Thank you.
Thank you so much, Your Worship. We shall take just one more question from His Worship Zirintusa in the interest of time, and then we invite the speaker to us.
Sorry, the last thing I forgot is on the issue of filing in a wrong court. Has the system been rectified that if a matter is supposed to be in Wakiso, the moment I start inputting the village, it will automatically direct me to where the cause of action is. And then we shall have no issues of transferring cases to another court. Is it already like when you're registering for passports or national ID, the moment you input your village and your sub-county, whatever, it automatically brings where you stay. So I'm sure IKIMIS can have that provision, as in where the cause of action happened in Kakiri. So I cannot find myself in civil division when the cause of action was in Kakiri. Thank you.
Thank you so much. Mr. Senabulia, please.
Thank you very much, Your Worships, for those questions. I think let me begin with the last one. We looked at the form that we used for filing cases, and we looked at the various fields that are available, especially if we want to file a case. In the beginning, people were complaining that most of these fields are even many. So for us, we are very flexible as IT. If you say include these other fields to help us do this, we can be able to include it. Now, these are the fields that are available when you are filing a case. So it does not, you are the one selecting the court where. I know some of these litigants might not know the jurisdiction, especially for these newly created high court circuits. I know some of you registrars were also calling me, asking me, where does Wakiso end? Now where does Entebbe begin from? Because they are a bit mixed up, especially when they had just opened them up. So at the time of creation or at the time of e-filing, we only allow you to select the court where you are filing. The way even the manual process has been happening, they have been bringing these files to your courts, and you've been sending them to go to the particular courts where they are supposed to be filed. So that's the same way the system was modeled. Now, if you want us to use sub-county and village, then that means at the time of filing, we shall ask the lawyers we include those two fields, sub-county and village. Then they select the village. So that means we shall have to map all the villages based on the high court circuits that we have and the sub-counties. But now that will be coming from you as a resolution, whether it's information that is required at the time of filing. Then we include two fields here. Then we peg those fields to each and every high court. We shall do a mapping of all the villages under a particular high court circuit. But now this needs a committee, which will also come from you. For us as IT people, we implement what you discuss and agree and give us to implement. You know all the villages. Either we work with you, boss, and get all the villages and map them to a particular high court circuit, because it might be very hard for us as IT people now to know where the boundary of Wakiso High Court from Entebbe, whether CISA falls the other side or falls this side. So it's going to be very hard for us. So that means we shall have to get the information from either Electoral Commission or UBOS. Then we start doing the mapping. Kampala High Court, all the villages and sub-county, Wakiso High Court, all the villages and sub-county. Then we begin implementing them in the system. But still that might not solve this problem. Why? Because people are going to select them wrongly and they will be filing them in your courts. And you'll still have to. So we are trying to reduce it, but remember those lists are going to be very long. So when some of these litigants are tired, they just simply select what they feel they like at that point of filing. But we shall have reduced, for those who are knowledgeable, some of them even don't know their villages. Or they select what they prefer at that point in time. So that means if I'm to get Wakiso, I map all the villages, and when someone scrolls through that list, by the time he gets to the last village, he's already tired. So they might just put it there for the sake. But we still leave it to you. If you agree, for us we are flexible. Then we shall have to compose a committee from amongst yourselves. We collect that information from either NIRA or NITA or WUBOS or Electoral Commission to help us give us those details. Then we shall map the districts that we have in each and every High Court circuit against that. Then we can begin implementing in the system. But that comes from you as a resolution. Then let me go to the, I've begun from the bottom. Register all election petitions in civil divisions or at circuits. Still this is dependent on the resolution that you make. I don't know whether it is made by the Chief Justice or who, as long as they agree to register them, the system will be open, telling us. The only field I think we need to include whether this election petition is coming from Mbale, so that they are clear. Because now as the system is, it's not able to tell you whether this petition is coming from Mbale or Mbarara or where. So you just register it as long as you select the court. So unless, if we want all of them to be filed under civil division, Kampala, we can do that on the system. It is open, they can e-file. If there are any additional information that we need to capture on those election petitions indicating the district of origin, then that means we have to amend this form again and include district of origin, so that we map the district to the case. At the time of allocating these matters, we can get judges and know the ones from Mbale can be allocated to the judges that are coming from Mbale, and so on. Then the other question was related to the audit queries. Yes, there are audit queries that happened, and I think that audit has been closed down because some of the things the auditors were asking were not realistic. So amongst them was the payment of court fees. At that time when we had just started IKIMIS, there was both manual payment and electronic payment. So lawyers were permitted to upload receipts on the system, and the moment we would see the receipts, we would just admit these documents as proof of payment. Unfortunately, when we checked some of these receipts, they were forged receipts. When the Auditor General printed out those receipts, you check against the PRN number, you realize the PRN expired long time ago, and the money was never paid. And the document was already admitted by the registrars. So they wanted us to go ahead and even verify the receipts. But the receipts looked very authentic. I got some of them. Some of the lawyers would send me some of these receipts and they wanted to generate them. So from the system, they give me the case number, I would generate for them. But when you look at the receipt, it looks very genuine, from Diamond Trust Bank, in its red colors, signed by the teller, the names of the teller there, even the date of payment. You couldn't even tell that it's a forged receipt until you get that PRN, put it in the URA site and cross-check. You find the PRN expired long time ago, and the money was never realized. So that's why the resolution of saying all payments on IKIMIS should be electronic payments, and the status confirming payment should be coming from URA site came from. So nowadays, no receipts are permitted. When you pay online, they tell you go and pay on the system, claim your refund from URA. So those were some of the issues that happened. The biggest one, especially from Auditor General, was in regards to payment. The money was being lost, especially for the cases in commercial. Many of them were not paying. They are filing cases in billion shillings. You look at the receipts are not genuine. The money has never been received in the consolidated fund. So that was the biggest issue. And they wanted to peg that financial loss onto us, that we are the ones who caused, but that was resolved by top management. So the audit was closed. Then, okay, there was a proposal to give me the list of payable fees. Yes, I'll be glad to receive that list of payable fees from you for purposes of implementing. Now, the issue of resemblance of pleadings that are filed on the system, it is true. There are certain documents that resemble pleadings that are filed on the system. But the system is not take to AI and scan through the documents that you upload and read and tell whether the document is drafted as a pleading or a plaint. It is not able to do that. That's some level of AI. Maybe we shall get there in future, such that whenever you upload a document, it actually proofreads and confirms whether this is a plaint or you filed a notice of motion instead of a plaint. It's not able to do that. So it's a human that has to read through it and then be able to confirm. So the best we can do now is to tell it, please, the mandatory document is this. If someone has not selected a plaint when he's filing a civil suit, don't accept to save and give a number. That's what we are doing right now. But even for these other documents, where it is not activated, that means one of the people called us and told us to first deactivate it. That comes from the fact that there are cases that are migrated from CAS that are being worked on, which did not have pleadings on them. So when someone wants to work on it and they don't want to upload, the system asks for the mandatory pleading to be uploaded. And some of you judicial officers tell us, where can I don't want to go through this process of uploading this mandatory document. So you find us relaxing some of those constraints to allow you to proceed to work. And some of you call when issues are very urgent. You tell us, I want it now. So when you tell us like that, at times we relax some of those restrictions and permit you to proceed without the mandatory proceedings, especially in the old files that are transferred. The best you can do, I've seen some courts doing it. Mukono is moving towards it. Criminal division is doing, they are scanning all their documents, even in the previous files that they had, to be uploaded on IKIMIS. So that when they are reading a file, the physical file, they are now focusing on what is on IKIMIS. Even for those files that were filed in 2015, 2014, they are doing it, scanning and uploading on the system. So at least we believe that if all that is done, then we shall be able to implement these mandatory requirements as they are expected to work. The issue of timelines, you want us to implement the system so that it's the one that can take action, especially in as far as timelines are concerned. If that's a resolution that comes from you, I remember even in the presidential election petition, it was an issue of debate. Then there were issues of applications being filed to permit litigants file out of time, and you hear those applications. So shall we keep closing, opening? There was an issue there. So if I close 30 days have elapsed and the system logs out, then the other person files an application for filing out of time, you're actually giving him more time to prepare his petition as you are preparing also to hear the application. By the time you tell him now you can file out of time, additional 10 days have gone. He has actually concretized this evidence now. And we are opening up the system again to permit him now to file out of time. So the discretion still lies before the judicial officer. Unless you want us to take away the discretion from you and now give it to the system to be able to accept or deny, because now the system will be doing it for you. Then the same applies to the fees. When we were designing the court fees, we wanted to make it mandatory that all cases that come on the system have court fees paid. Then some of your colleagues told us it's the discretion of the judicial officer to waive fees or do so. And they pulled out the rules and showed us where it is written. So now, if we say everything should pay, even if someone files an application for waiving of fees, it's the system that will be closing. So even if they file for us, the system would have been implemented to close everything. No moving forward without paying of court fees. So that is something that you have to agree on so that we can bypass the rule and proceed by doing things electronically.
The rules you're referring to is suits by paupers. For a person to file, they must have first secured an order permitting them to file without paying fees. The assumption is that everything that comes in has to be paid for. If you can't afford, you bring an application before filing, and then court grants you permission to file without leave, to file without having paid fees.
Chair, Mr. Sanabria could also be talking about a scenario where a party pays less fees and the court asks him to top up. So that is what he could be talking about.
No, but that is different. Like here, if the system gave the person 6,000, then we would ask him to go and pay 140 something money. But now the money should be configured fees for election petitions, such that they don't select petitions for divorce or petitions for letters of administration.
Okay, thank you very much, Your Worships. Now I was using the training environment. In the live environment, these things are configured. So the training environment, we keep changing these things. Even the judicial officers that are in particular divisions, if I go to civil division, I won't find the judicial officers. That's why you saw me selecting Douglas Singiza, much as is no longer in civil division. So the data that I have in the training environment, any of us, the technical committee members, keeps changing this data for purposes of suiting their training. So please, in the live environment, things are going to be different. That's why I couldn't even complete the payment module in the training environment, because I'm not actually working on the live environment to show me how much I'm supposed to pay. But all these documents are listed the other side. Maybe what I need to confirm are the fees. We usually have issues relating to the fees that are supposed to be paid. Even at the time when we were configuring them in the system, we went around collecting court fees schedules that were used by the different divisions, but people would put others written in handwriting. And when the auditors would query us, where did you get this fee? Someone would bring out, some of your cashiers would bring out these court fee schedules and tell us, it is the registrar who was once here who told us we should charge this on this particular. So we have so many issues. Even in the technical committee, I'm finding it as a challenge because some people don't want to commit themselves in as far as the court fee schedule is concerned. So I'll be very glad to receive the updated one from you. If this forum is able to give it to me and recommends, I'll use that as a benchmark and rectify all the issues that relate to fees here. But for now, I'm using what I collected from those divisions, from the different cashiers, what they submitted to me. But the list keeps increasing. We keep populating it with additional ones that keep coming up in the course of doing our work. So that one is, we are flexible, we can be able to update that. But for purposes of preparing for the election petitions, at least if you can give me that one so that I confirm whatever I have under the court fees that are supposed to be paid, I'll be very glad to receive that. There was some question. Okay, there was a question whether we can be able to use the laptops that you are given to do the recording. Yes. The other option that you can have, which some of your judicial officers are already using, your laptops come with an already embedded recorder for Microsoft. When you click the Windows key and Windows H. Let me just demonstrate that here so that you can be able to see how it works. Actually, some of your colleagues are already using it for recording and transcription. So
ICT support, can you please link him so that he's able to demonstrate while we are seeing on the screen?
So the keys that you can place, the shortcut keys are the Windows key and H. Windows H on your laptop, it will bring you that icon for recording. So it starts listening in and transcribing. You open a Word document in the background. So when you start, you see how it is typing whatever I'm telling it. Whatever I'm speaking, it's trying to write. So you can also use that. It's available on all your laptops. Windows. No, you open a Word document. I've now opened the Word document. Yes. Oh, you want me? I thought Word is already open. Okay, I look for Word on my computer. I open Word because I want the application to type under Word. So it opens like this. Now I go on my laptop, there are two keys. One is the Windows key and the other one is letter H. So you press the Windows key, then you press H. It will pop up that tool. The Windows key is the one that has the logo for Windows. Oh, let me just show it for you, show it to you here. Let me just go to one of the sites here and show you the Windows key. The internet here is disappointing me. Let me just connect to my internet so that we can be able. So some of your colleagues are already using these tools. I met one magistrate in Mukono already using it. So that's the logo for the, when you look at your keyboard, you look for that logo. That's the Windows key. That's the logo. When you press that logo, it's usually among near the space bar, the other big space bar key. So when you press that Windows key, then you press H, you hold it down, then press H as well. So having seen the Windows key, you press Windows key plus H. Then it shows you that it's now listening. It is even telling it's listening. So you start dictating. So as you dictate, it types for you the proceedings. So if you are in court, it will be recording whoever is surrounding that laptop that is given chance to speak and typing it out for you. But at the end of the hearing, you have the proceedings available to you. You just save. So if, especially in your chambers where there are not very many people, you are moderating the sitting, so you can just turn it on. They won't even notice that you are recording. They will just not know that you won't be even typing anything. It will be just doing all the work for you. Even if you have 10 pages or 6 hours of that sitting, it will be doing the work for you. So this one has no restrictions. You don't even need the software for transcribing. So I hope that is clear. Then there was a... For now, the cases that have not been paid, what you can do is to notify the parties to pay the court fees because they are being filed in your court. Actually, I think it's commercial court that was cause listing them and giving them time to make sure if they are still interested in those cases, they share them on their forums, tell the lawyers if they are still interested in them, let them pay the fees. Then they indicate those ones that are going to be closed that particular month. If the lawyers fail to comply, they close all those cases. So that's the approach they were using. Then, okay, there was an issue of the election petitions that are filed without pleadings. Yes, I told you now this one, there are rules that we put in the system, and you can relax this rule depending on the demand that comes up. So I usually do it if there is an urgent need that has a request that has come from me, especially if you're working on old files. So at times when I relax that constraint, I don't usually turn it back. But if you want me to turn all of them on, there is a time we turned all of them on, and every time we were receiving so many calls in our call center because judicial officers didn't want to keep uploading these documents. They still wanted to refer to the physical file, especially for that data that was migrated from CAS. And the system would insist first upload the pleading before you can perform an action. Even if it's just moving this case to under hearing or even allocating it to a judge, it will say first upload the pleading. So the system sends you a reminder. The same happens to the court fees. That's why we only put the reminder. The reminder keeps popping up to remind you to pay the court fees, but we didn't want to take away that discretion from you. But if you agree, then we can close it down and say whoever has not paid fees, don't permit this file to be registered. I know I had a discussion with so many people on that same issue, including judges. And they told me don't take away the discretion of the registrars. So, but I will take it from here and present it back to the committee. And we have another discussion because now it is becoming a very big issue in the system. There are so many cases that are lying there without paying court fees. I think those were the questions. For files that have been filed 10 times, what do you do on IKIMIS for files that have been filed like 10 times? Some of them don't have documents. You look out for the one that has the documents. I know some of these people, instead of practicing on the training environment, they come on the live environment and they keep practicing. He puts one party or two parties, then the case has 5 parties, then he abandons that case, he creates another one. But good enough, the system is able to filter out those cases. What you need to do at the end of each month, you need to just do what commercial court is doing so that you clean them out of the system. Otherwise, the number will grow to 1,000 without any action taking place. Your Worships, I think those were the questions, and I thank you for listening to me.
Your Worships, I want to invite you to give a thunderous hand clap to Mr. Senabulia. Mr. Senabulia, I would like to extend my sincere gratitude to you on behalf of all the members here for your candid and quite engaging and insightful presentation. As we set out now on the e-journey in election disputes, we hope that what we have said here will form part of the reforms to see in a couple of weeks. I also want to thank the Judicial Training Institute for having invited you, and we look forward to sharing your presentation and the reforms with us. Let's give him one more thanks, and I now return. I want to apologize to you for having not kept time, but you saw how sensitive the topic we were bailing out was.
But the registrars have a critical role to play in the success of these activities. And through experience, you'll find that many of the hitches that take place, especially in and outside the courtroom, you have control over them. The judges you are going to work with are going to be trusting you, even for the unforeseen. When something goes wrong in the courtroom, they ask, where is the registrar? Where is DR? Where is AR? So you need to be at your best, so that, because this exercise comes with a lot of pressure and shortness of time. So you have a lot of things to do within a very short time, but you cannot afford to get it wrong. You and the entire court, the judge, you and the entire court have to get it right. So you have a role to play in the presidential election, in the parliamentary election petitions, and in the local council election petitions. In each of these, the registrars are attached to that particular court will have a role to play. So this paper highlights the aspects which I think the registrars need to consider keenly in order to play their role efficiently and effectively. Now, in all the different categories of petitions, whether presidential, parliamentary, or local council, your roles include the following: management of the filing process, management of the filing of the service of process, ensuring compliance with form, procedure, and timelines, prompt reporting in case of non-compliance, management of the team at the court for the specific task, supporting of the trial and determination of the petitions, extraction of decrees and orders, taxation of bills of costs. Let's look at the common hotspots. I know that you have gone through some discussion of the applicable law and the general management. But here I just want to draw to you the things that you should keenly look out for. The first is the prescribed form of the petition. The rules are specific. They give a form in the schedule of how the petition should look like, should comply with. Of course, that doesn't mean word by word, but it means in substance. There are some things that must be in that petition. For the presidential, the rules are different. For the parliamentary, the rules are different. And there is also this appeals to High Court from decisions of commission rules. Those ones also have, the petition is different from the one for the parliamentary. So please look out those rules and read them. They are specific such that if the petition doesn't comply with those provisions, and the judge notices it when they are writing a judgment, or when they are in the middle of a hearing, you will be to blame because you received it. Even if the judge didn't see it, he assumes the moment it's on file and served and responded to, he assumes the petition is proper. Now, the blame goes to you because you are the housekeeper. So, now, if you look at the petition and it doesn't comply, please consult the judge, or if you are at an appellate court, Court of Appeal and the Supreme Court, consult the administrator of the court for him to take a quick decision, him or her, to take a quick decision as to whether they refer the petition back or validate it the way it is, because time is of essence. So you should have a clear communication line with your judge or administrator of the court. This idea of waiting, that let's wait until Monday, time will have run out. So even if in the usual course of business you don't call your judge, you don't call the administrator of the court, for this period, please just speak to them and tell them to be available on phone, even at night, because now with the ECMIS, they can file something at 10 and you notice it's not in a proper form, and tomorrow is the last day of filing. You should be able to contact your judge or the head of the court and tell them, I have this scenario, should I validate? And you don't just reject, because if you reject and for some reason the following day you get busy, you don't address it, the other people assume they have filed, the time runs out. Now you go in, the court goes into an argument as to whether there was filing within time or not. And you know that with electronic filing, it is not deemed filing upon completion of the process. It is deemed filing upon the first attempt by the person. If the person attempts and for some reason is frustrated by something beyond their power or means, the proceeding is deemed filed. And now I'm talking, that is in respect to courts which are under ECMIS. Of course, courts outside ECMIS, the usual rules apply. But the point here is, once you notice a defect that you know the rules provide otherwise, please bring it to the attention of the judge or the administrator of the court, and they take a decision. Don't take that decision because it will be used against you. A decision to reject a pleading in an election petition is very serious, because the court can go and appeal on that ground, and then they order retrial. So the judge is going to hold you accountable that you messed up their work. Now, the time for lodgement of the petition and any other documents, in case of any non-compliance, please report promptly. Now, the rules are very strict on time, and these provisions are in Acts of Parliament. You should know that the court has no residual power to extend time set by an Act of Parliament. So which means the decision as to whether the petition has been filed in time or not is critical. Now, the moment a petition is filed out of time, please don't reject it, but report to the judge so that they are aware of that and see the best way of handling it. Now, the other aspect is the number of copies. The rules also provide, especially in presidential petition, the number of copies that should be filed by the petitioner. The number of copies that should be filed by the respondent. Please be keen, because if you don't, and after you have signed, you give to the process server to serve, of course for them they will not be aware. If the copies are few, depending on their attitude, they may just serve those they think are important. They serve the first and second respondent, and they believe that's okay. But there are a number of, the rules are elaborate on how to serve, who to serve. So, where the rules specify the number of copies, please ensure the petition is filed in those copies. And the respondent, the respondent's response is also filed in those copies. And where the rules provide that the petition should come with some supporting documents, ensure those documents are attached. Because if they are not attached and it's an anomaly, the petitioners will say the documents were there. So they throw the ball to the registry. They even show their copy, which is received, and they say, this is the complete copy, this is how it looked like. And at certain point in time, that's enough to defeat a petition. Simply because, for instance, if it's a petition with no affidavit attached, there's no petition. So if you receive a naked petition, then there's a big problem. Because if the time runs out, then the court will deem there is no petition. But now you'll find that the actual naked petition was filed way in time, but it had no supporting documents as per the rules. So they always put the problem on you. The petitioner will always find a way of putting the problem on the registrar. So most of that time, of course this I may forget, please sit in court, especially for the presidential petition. There's no choice. The registrars must be in court. You don't rely on the clerk. Now, even in parliamentary petition, be within. You can do other work, but where you can, please sit in court. Because when you are there, the lawyers will fear to lie against you. But if you are not there, they lie against you, and when they tell about 2 lies about you, the judge will just give up about it. Say, I think my registrar is fake. How could she not do this? How could he not do this? You understand? So they will make you responsible for their own anomalies. And the anomalies are many because everyone is acting in a rush. The petition has very few timelines. For instance, in these appeals to the High Court after commission decisions, it's either 2 days or 3 days to take a particular act. The court itself has 7 days within which to handle the petition. So there is a lot of rush. So many mistakes happen, but everyone should be able to take responsibility for their own mistakes. Now, there is the issue of payment of fees and the prescribed security deposit. Each of those rules provide for payment of fees and a security deposit. Now, the rules provide that if the fees and the security deposits are not paid, the petition shall not be received by the registrar. That's what the rules say. But I urge you to act wisely. Don't just reject the petition and go on with your work. Advise them to pay the fees within within a reasonable time, whether hours or minutes or a day, if they still have time. And in case the time you have given them they don't do so, please consult the judge as to whether to enter that case or not. And please don't wait for time to run out. Now, the other aspect is the proper service of the petition, notices, and other documents. This is one of the area, one of the most sensitive areas. After the petition has been filed, issues of service are the most controversial, because there is a tendency of respondents wanting to avoid service, proper service. They want to use lack of proper service as a ground. So they are doing their best to make you, to make it difficult for you and to get a mistake from the side of the court and the petitioner. So they will hide, they will give wrong addresses, they will, So you have to be very alert on the aspect of service. And you have to follow the law. Most of the rules indicate that personal service is the first option. But where a person cannot be served, some rules allow the other party to apply for substituted service. Some rules dictate that upon being served, they indicate that the respondent will be asked to provide their address of service. And if they don't do so, you, the registrar, direct service either upon the address that is at the foot of the petition provided by the respondent, or by affixing a copy on the notice board. So get acclimatized with those rules and evaluate the circumstances and see what is the best way of doing it. But in all this, be in touch, as I said, with your judge, so that they don't blame you. For everything that goes wrong, the judge will blame you, because that's about gatekeeping. Everything about gatekeeping and housekeeping, you will take the blame. But if you consulted the judge and said, serve by this method, if that method backfires, then you have done your job. So, and of course, be keen on the mode of service and the timelines within which service should be done. If service is done outside, it's also a problem. So you would have to advise parties where the law allows, instead of doing ineffective service knowingly, you advise them your time has run out, please apply to the court for either extension of time or for a substituted mode of service, so that you don't do post-mortem. Now, there are requirements for publication of notices in the Gazette, newspaper, or the court notice board. You have to adhere to these requirements, because in certain instances, even when service has been done personally on the respondent, there is a requirement that a copy of the notice shall be published in the Gazette. Please do it, because if you don't do it, it has a legal effect on the proceedings. So you have to adhere to those requirements. Now, there are requirements for furnishing by the respondents of their address of service, and the rules provide for what happens in case of non-compliance by the respondent. Sometimes the rules say if they are asked to provide their address and they don't, the registrar directs service on the address that has been provided by the petitioner at the foot of the petition where one exists. Or, for instance, like in the parliamentary elections, it says you can order service by posting on the court notice board, and it can be taken as sufficient proof of service. Now, there is a need for clarity on the time and the place of trial. When you are issuing notices, please ensure time is specified. The people may be used that the judge in this place starts their court at 10 or at 11. And they assume that when they are summoned for an election petition, the same rules apply. Now they get a judge who starts their court at 8:30. And by the time they come, they have already assumed the other people were served and they have not come. So please be clear on time, and where there is an issue of where does the court sit, also be clear on that. For instance, taking like the civil division, at times if there could be more judges than the spaces. Last time, in the last electoral cycle, some judges doing petitions of the civil division sat at the headquarters, at the High Court headquarters. Now people will be rotating around to it. Meanwhile, where the judge is seated at the headquarters, they are making orders against them, either to proceed ex parte or to dismiss the petition. So make sure that clarity exists. And there is also the prescription on when the hearing should be fixed. For instance, in the petitions, pre-election petition, appeals to the High Court from decisions of the Commission, the rules provide that the hearing date, after you have completed the process, the pleading process, the hearing should be fixed within 2 days, in a space of 2 days. So if you are not alive to this, and you give people a date according to the schedule of the judge, 7 days away or a week away or 2 weeks away, that's already a problem. And the judge may not sit at that time. The judge will not sit later when they are scrutinizing the paperwork and the rules. So it's you to point out to the judge that these rules say from this point we can only have a hearing date within 2 days. Then of course the rules say the judge should abandon or put on hold any other work and deal with this. So there's nothing like the judge has no schedule in their calendar, because the rules, all the rules, whether presidential, parliamentary, and these other ones from the Commission, they have that provision that for purpose of disposing of these petitions, the judge should set aside all other work and deal with this. So you should be keen on the timeline set within which the petition should be handled. Now, the rules allow the registry to remain open and hearing to take place on weekends and all public holidays. So you need to make appropriate arrangements and communicate accordingly. So where need arises, for instance, if the judge, if the filing needs to be done over across the weekend because of time, or if the judge has to handle the matter including a weekend or a public holiday, please make appropriate arrangements to ensure that that is done. Now, there's the issue of crowd control. In most petitions, of course, the crowds will be unusual, and their mannerisms will also be unusual. There will be fights, there will be quarrels, there will be noise, even in the courtroom. So the order by the clerk may not calm these people down. So you need, first of all, to have presence of security, sufficient security on the ground, such that if a person becomes rowdier than can be controlled by voice, then they pull that person out. Or if people want to fight, they restrain them. But you are going to find these things. When in the last electoral cycle I was in Arua, I handled election petitions in Arua. Now, one of the petitions was of the city mayor. It was the most controversial. So on that day, the people were too many that they couldn't fit in the court hall and in the court and in the compound. So they had to lock some of them out of the gate. Now, that was enough to tell me what is coming. So fortunately, when this petition came up for scheduling, I talked to them about ADR and tried to use some ADR tactics to cool them. My major aim was to cool them. Unknown to me, the first day the petition came up, these people told me they have settled. I was very, very relieved, because it was the most chaotic of the petitions. So for the first time I saw ADR succeeding in an election petition. I didn't try that petition. So at times you have to use both psychology and you have to use the carrot and stick method. You get to talk to the people in different ways. Summoning and swearing of witnesses. Ensure summons are extracted. Don't just tell the clerk, oh, the record person extract someone. They will forget. Ensure they are properly served. Ensure relevant instruments for oath are available. Do you know how embarrassing, for instance, if you are in the presidential petition, you are the registrar, and they summon a witness for cross-examination, and there's no Bible or Quran. And you have to first run somewhere to pick it, and for some reason, the person who has the key is not around, he has gone for breakfast. And 7 or 9 judges are seated waiting for the Bible or Quran. I assure you, you will go back with a heart attack. By the time you enter with the Bible, after 5 or 10 minutes, you'll get a heart attack. So don't take anything for granted. Ensure the Bible is there, the Quran is there, and that the clerk knows the oath, because we may assume at times, for some reason, for that petition, a clerk who does not usually go to court may be the one who comes. They think it's a question of sitting there, and they don't know the oath. So have the oath typed so that the witnesses can read it, or this person can lead them. So it's at that level, it's not the work of the clerk. You have to prepare that clerk who is going to sit there as a clerk, but it's your work that they are doing. Now, order for costs. Ensure the order for costs is clear when the court makes the decision. Ensure the order for costs is clear. At times there is a controversy. The court can be ambiguous, or whether they have ordered, for instance, costs against both respondents or against one respondent, or costs in favor of both respondents or in favor of one respondent. Now, ensure the order for costs is clear. If it's not clear, please get back to the judge for that clarity. And where the order is passed against the petitioner, the rules provide that you first resort to the security deposit they made before you issue execution. You order that they forfeit the security deposit they made, and then you execute for the balance. But where no costs are ordered against the petitioner, that security deposit is refundable. For instance, if the petitioner is a successful person and they are supposed to be paid costs by the respondent, then you order for a refund of the security deposit they made. Now, compiling and certifying the court record and the record of appeal in case of an appeal. This is another area. Some registrars believe by that time they have done their job. By the time when the case comes for trial, judgment. Now, in many cases, an issue arises when either parties need a copy of the record or the record is needed for purpose of appeal. Please ensure that the record is properly compiled and proofread and certified. That's another area that usually creates a problem for registrars. At times, the idea of simply certifying, your secretary types, the clerk brings for you with a stamp already there, and the auditor is to sign. They will take a record that is incomplete or inaccurate. And if it's going on appeal or for some official purpose, you'll get a problem. Someone will lose trust in you. When they read it after the query, they'll say, but you man, did you go to the law school? You know? How could you sanction this? And that can be very, very insulting. Now, there is the issue of taxation of bill of costs. You ensure that the taxation is in compliance with the rules. There was a history of people claiming too much money in election petitions without justification. An advocate claims for instruction fees of 200 million. But it has to be based on the rules. So it's not like a party that or a windfall that once you succeed in an election petition, you get all the money that you want. Please restrict yourself to the rules because it can cause you an issue. Now, there is the idea of a certificate of 2 or more counsel. Some advocates, because they appeared together, when it comes to taxation, they want you to enforce costs with a certificate of 2 or more counsel. Now, the rule is that the court must have pronounced itself on that. So, when the lawyers are submitting, they always ask the court to award costs with a certificate of 2 or 3 or 4 counsel. And the court must pronounce itself on that. If the court doesn't, it's assumed that the costs are for one advocate. If they become argumentative before you, you refer them to the judge, either to ask for a review or a sleep rule, supposing the judge just forgot. So, but you don't give costs for a certificate of more than 1 counsel unless the court order indicates so. Now, execution process should comply with the rules and be done after the final order. If there is an appeal, there is no final order yet. You can't issue execution, even without a stay. So we know that under the law, an appeal does not automatically operate as a stay of execution. But for purpose of election matters, once there is an appeal, don't execute. Wait for the final order by the Court of Appeal. Constant and effective consultation with the judge is a must. That one, I have to re-emphasize it. Please, that will make you succeed or fail. Because, as I said, because of the shortness of time, many things will definitely go wrong. But if they go, if you combine the heads and things still went wrong, that is fine. It means it was unknown or human error. But if you decide to do it yourself, you use your intuition or your common sense, it can backfire, and someone will tell you, but couldn't you see that this should have been done this way? Even if at that time they were themselves not aware. Now, there is the issue of financial management and transparency. Ensure proper financial management and transparency. Now, there is a thinking, especially on the part of your staff, that this kind of cases come with a windfall. They will assume you have gotten a lot of money, and everyone expects a lot of money, and funding of so many unusual things. Please, be transparent. Let them know what is on budget and what is not on budget. And let them receive their allowances. Because in some cases, what creates a problem, some people, they keep a blind eye on these people they work with. They fund all the other things, and they are looking at making a difference, and they don't fund the other court staff. Then the rumors will fly around as how the court got 300 million. They start asking, where did it go? You know? Now, and maybe by some hard luck, you had already ordered your car in January. In June, they see you driving a new car. Now they say, you see, he got the money from from the petitions. So they name your car Election Petitions. You know? So ensure you are transparent, and also ensure the funds are well budgeted, because this is the kind of activity you can't tell a judge that the money is over. The petitions must be done within a particular period of time. So whichever amount of money sent should be able to be enough. So that is a role that you need to properly play. Now, in conclusion, election petitions come with an environment that is different from business as usual. So you have to prepare for and handle the environment adequately well. So it's not going to be the usual same thing. Courts are going to be full. The courtyards are going to be full. The demands are going to be many. So it's not business as usual. So you prepare yourself to manage that environment. Of course, the law is emphatic on timelines for filing, service, hearing, and determination by the court. Be keen on this. And don't drop the timelines. Of course, please read the rules. Those rules are not so many. None of the rules has more, I think has more than 20 provisions. So please read them and see where your role is. If you take it that the petitions are for judges, yours is to receive what they bring, you'll be in trouble. And of course also prepare in all other respects. Just do preparation. You have heard of the 3 P's: preparation, preparation, preparation. So if you do that, you are able to succeed. So thank you very much. That's it. Marks the end of my presentation.
Colleagues, here is an opportune time for us to interact with Justice Wamala by putting questions to him. Yes, we shall start with my brother from Mubende.
Thank you so much, my Lord, and thank you so much, Diara, for moderating well. My Lord, you talked about situations when 2 lawyers file separate bills. What about in situation where there's a growing tendencies of lawyers filing separate bills, one lawyer representing the plaintiff, and there are 2 defendants, but they want to file 2 separate bills against each defendant? Because they have 2 different lawyers, so they want to file 2 separate bills against those defendants, almost same figures for the same suit.
What has been your experience in handling this as a judge, as a registrar, as a chief magistrate Then you're the support engine for the lower bench. The chief magistrates in your area coming to you for consultation or asking, how do we go about this? How do you ensure a systematic way of communication upwards and downwards to ensure that the communication does not break, but you all sound the same drumbeat? Thank you, my lord.
Okay, thank you, your worships. Now, on the issue of separate bills, if advocates, different advocates are representing a petitioner, a sole petitioner, or actually a number of petitioners presenting one petition, they can't file separate bills because the instruction is to a team of advocates. An advocate, a petitioner cannot instruct 3 different advocates to file 3 different petitions. They file one petition. So the instruction is to file one petition. So now, if they have worked as a team, that's the only justification for them is to ask for a certificate of 3 counsel, and they justify it. Because at times the court may even refuse. If it's a simple petition which has no new idea, new novelty, the court may refuse to give a certificate of 3 counsel or 2. It's one that could have been adequately done by one. It means they share what they receive on the certificate of one counsel. So you cannot accept bills in one petition by different advocates. And where, of course, as against the respondents, it's different, because if it is the winner and the electoral commission, they will file a bill against each respondent, because you can't claim from the respondents. The respondents were not defending similarly. So they would file one bill against each respondent, depending on the order. Because at times the court may even order that the costs be borne by the second respondent, in which case, for instance, is the EC. So that means they can't file a bill against the first respondent. They'll file it against the second respondent, like that. Now, your worship, about the pressure, of course, as I've said, the pressure will be there, and a lot of it. But the first winning tactic is preparation. If you are prepared for each of those eventualities, that alone will diffuse pressure. Of course, the other one is also to be intuitive and to be resilient. If you're a prayer person, you really have to pray that things don't go wrong for the sake of going wrong. Of course, for the registrar, you have your choices don't even include switching off your phone or switching phones. For you, the judge may decide to change phones or to restrict who call him or her at that time. But for the registrar, your phone must be on 24/7. You just need to know how to navigate pressures. But the advantage you have is this one: you are not making any decision on the merits of the case. So the people who would want to compromise the process really don't have much headway with you, because all you have to show, actually, for you can even pretend, I don't know what is in your petition. Me, my duty does not involve. You can pretend you don't even know their petitioners before you. You can, because your work is in the background. And of course, never allow to be used to approach judges or to discuss these matters with judges. Because for some reason, you may have a discussion with the judge concerning this petition, bordering on the merits, and after some days he hears some people in that petition paid money, or they are celebrating before he delivers the judgment. He will definitely suspect you. The judge will definitely suspect you. So avoid being used by whether relatives or to think of taking money to judges or trying to find out the mind of the judge. That one you have dug, because you see, in almost every electoral cycle, there are stories of people who have paid money, actually, and some have actually paid it, but only that maybe it hasn't reached where it was going, or someone defrauded them. He told them, yeah, I know this judge. They get a hefty sum of money. These people believe the judge is already deciding in their favor. You have had stories of people celebrating the night before. The ruling is, the judgment is tomorrow, and this night people are celebrating. Some of those are actually genuinely believing that the thing worked. You know? So, that's one way. But Justice Ketrima here, he has very good advice on that soft skill of pressure and how to handle pressure. I request my Lord to speak to these people about that aspect.
That's the biggest weapon. They say when you argue with a fool, you also appear like one, not so? People in these times will come, they will abuse you, they will bombard you with all sorts of demands. So you just maintain your calm and you move on. You are assertive, but you are calm at the same time. People at times want to prove their assertiveness by also being loud, okay, retorting back. That's what at times some people want to draw you to. But your calmness can actually deflect somebody who has come to you with so much pressure. Of course, the other aspect is that the social media might be so hostile. So yes, your phone should be on, but maybe you should avoid social media, because that has an influence. It can have an influence on you depending on how people are reporting about you. You could read that later on. But as for the calls, as His Lordship has said, you should be open 24/7, because one, you'll be needed by the judges and you are the administrator of the court, so you have to give direction. You can't afford not to be available during those times. And of course, you could take off some time, doing some exercise, relax. That also helps. And get comfort also from a colleague when you are faced with such a situation. If it's a superior, you could say, what would I do in such a circumstance? And once you get that brief from your superior, you are comforted and you are able to move on. But just know that these pressures are on everyone. It's not you alone. It's not in isolation. You will not be the first, nor the last. So just be reassured that these situations have encountered other people, and so the way they respond, that makes a difference.
Thank you so much, my lords. My lord, we have a question from His Worship Dr. Lubowe.
Thank you so much, Your Lordship. Certainly I was in Arua when I saw mediation work in that very, very contentious matter. We also did some mediation at the Court of Appeal, the appellate mediation, which had its own questions. The question I have for you, my lords, as someone coming from the ADR registry, to what extent can mediation or alternative dispute resolution be institutionalized in these kind of petitions? Because we already have an army of very good mediators. Is there a way we can get prepared to ensure that we deploy some of our mediators to assist us in the petitions? Thank you very much. The one I was talking about at the appellate court was where someone was kicked out because of academic qualifications, and now when the matter went for appeal, there was a settlement saying the person who had been kicked out was actually, he had the papers, and they had actually settled the matter, and he was going to continue in Parliament. Your comment, my lords.
Of course, ADR is very instrumental, but election petitions have two peculiar aspects that make ADR a 50-50. One is the volatile nature, the kind of interests are not so personal. This person who is the loser who has petitioned, he has a group behind behind him or her. And much as he could see reason to settle, his group may hardly see. So some of these people pursue this as a bridge to the next, because if they just give up, the people say, this one is a coward. So that means even in 2031, they have gone. So some of them want to make a point that we had won, but they stole our vote, and the courts have let us down. Let's wait for 2031. Now, a person who has that kind of agenda, you can be most certain ADR will not succeed. Now, the other aspect is the timeliness. The time is too short, such that if people are going to settle, if people are going to mediate, you basically can only give them 1 or 2 days. Now, that becomes problematic, because usually in mediation, people are given, they give positions, they go and think, they come back, you caucus. Now, it's not, that time and opportunity is not available here. So that is also an aspect that makes it a bit hard. But it's always, we always have to try in mediatable cases. And as it is, our regime, our ADR regime properly applies to election petitions. So, for instance, if you know, if you as a registrar, you can see that this case is mediatable, and you know a seasoned mediator who can mediate this. It is useful for you to speak with the judge, because what I know is, when we schedule cases, you may find that one of the not every case is coming the following day. You may find you have done a scheduling on Monday, and one of the cases is coming on Wednesday, Thursday, Friday. Now, there's nothing wrong with having those, subjecting those cases to mediation as you wait for their hearing date. You never know when they come on Thursday, they may tell the judge, we have been discussing, and they believe by Monday we shall have a position. The judge would be pleased to say, okay, let's adjourn this case on Monday. If it doesn't succeed, I expect this to have been done, and on Monday we shall proceed with the hearing if it doesn't. In one fortunate case, you may find on Monday that these people come with a settlement. So the situation is all in for ADR. Yeah, thank you so much.
I will introduce Judge when he comes in, but let me start with Advocate Jude Byamukama. Advocate Jude Byamukama is a Ugandan advocate with over 15 years of experience. I'm glad to call him my classmate in so many aspects. He is a managing partner at JB Byamukama and Company Advocates, a full service law firm in Kampala, and a doctor fellow, just like I, at Huripek at Makerere University, and a research fellow at Development Law Group headed by Dr. Dan Ngabirano. He practices in high-value litigation, concentrating on constitutional, and human rights matters, civil litigation, commercial advisory, and has represented so many people in the courts of judicature. Still, I and him were privileged to work on a presidential petition in 2016. We were part of the JPAM camp. In 2002, he emerged as the best UCE student in Kabale from St. Paul Seminary. He's a former seminarian. Yes, let's put our hands together and welcome Advocate Jude Byamukama. Our next panelist would necessarily require no introduction. He's the main man of the house, the Honorable Justice John Eudes Ketirima, a judge of the High Court and the head of the Family Division. He has got over 25 plus uninterrupted years of service as a judicial officer, and he has been a member of so many committees within the judiciary and the past president of the East African Magistrates and Judges Association. He also brings a wealth of experience as a circuit judge. He did some cases in, I think I appeared before him in Arua during the election cycle still of 2016. The later Abiriga, yes. I was part of the crew there, and he was churning out a lot of jurisprudence there. But he also presided over a volatile place, Masaka, during the same election, handling both pre-election petition handling and post-election applications involving Donozio and so many other people in Masaka. At the time, he was a circuit judge in Masaka, and of course, he was also assigned these matters. Today they come to nourish our souls on what we shall be doing. Everything they've been telling us was complimentary. Now taxation is within our court. They speak to us about taxation of bills of costs in election petitions. Do we award colossal sums to stifle growth of democracy, or do we let democracy thrive without a fear of being penalized? And how do we execute these orders? My Lord, we shall start with you, with the experiences from the bench, and later Advocate Byamukama will speak to us about the expectations and lived experiences from the bar. My Lord, you're welcome.
Thank you very much. I think the most contentious time where you will be liked or hated by an advocate is during the taxation of a bill of costs. To some, it's a matter of life and death, because one, they are very expectant, and two, they know you have a lot of discretion to either make them rich or to make them poor. And therefore, depending on the outcome, you could attract criticism, you could attract hatred, and at times you could be suspicious. My experience as a registrar indicates that actually somebody can read into your bill of costs, I mean your taxation, and determine whether it was influenced or not. If somebody is with experience, he can easily determine that. So I want to caution you that this is a very tricky exercise. But the beauty is that it's a mathematical exercise. You are guided by what to do. So it's up to you to be guided or to ignore the guidance. And the guidance is statutory, okay? It's one area where mathematics applies. So, you could either apply the mathematics, or you could go out of it, and then you attract trouble. So by way of introduction, I say that a successful party in a suit is entitled to costs, unless there are good reasons to deny such a party costs. Now, my paper was looking at the High Court and not the appellate courts. I think Jude will dwell more on the appellate courts. And the object of awarding costs is not to punish the unsuccessful party, but to reimburse the successful party for the costs he or she incurred for suing or being sued in court. It's not a business venture that at the end of it all, if you are successful, you'll derive a profit from it. It's simply a reimbursement of accessing the court. So if you look at the law applicable, the Constitution provides adequate compensation shall be awarded to victims of wrongs. You look at the Civil Procedure Act, Section 27, subsection 1, which provides that subject to such conditions and limitations as may be prescribed, and to provisions of any law for the time being in force, the costs of and incidental to all suits shall be the discretion of the court or judge, and the court or judge shall have the power to determine by whom and out of what property, to what extent those costs are to be paid, and to give all necessary directions for the purposes aforesaid. The fact that the court or judge has no jurisdiction to try the suit shall be no bar to the exercise of powers in subsection 1. But the costs of any action, cause or matter or issue shall follow the event, unless the court or judge shall for good reason otherwise order. So it's until the judge makes that order as of costs that the party has a basis for filing a bill of costs. So the rest are the provisions of the law that are applicable. Now, we go to the terminology, which at times may confuse you. If you say, look at, if the costs are inter-party, the general principle is that as between the parties to an action, costs follow the event. That is, the loser of the action must pay the winner the costs. And costs inter-party are usually taxed or assessed on the party-to-party basis. That is, if there shall be allowed all costs as were necessary and proper for the attainment of justice or for reinforcing, defending the rights of the party whose costs are being taxed. I think this is something you are familiar to, inter-party costs. Now there are costs which are awarded in interlocutory proceedings. And costs may be dealt with by the court at any stage of the proceedings, when the judge may at the conclusion of the interlocutory proceedings make an order as to costs to be paid. I have seen a trend of some of the registrars taxing costs at interlocutory level and going ahead to execute. I think the precedents show that unless the judge directs that you do that, you are not at liberty to enforce those costs at that stage. They should wait until the final taxation of the bill of costs so that the execution is done at once. But of course, there are some instances where the judge could order that the costs be recovered at that stage. It's not within your discretion, if the matter is handled by the judge, for you to direct that the costs be recovered at that point. Costs in the cause. The effect of this order is that if the plaintiff is successful at the trial, costs will follow the event. The defendant will have to pay the costs of the interlocutory application as well as the general costs. The effect is the same, mutatis mutandis, if the defendant is successful. So the costs have to wait until the conclusion of the substantive case. costs in any event, the effect is that the party who succeeds in the interlocutor application is to be entitled to his or her costs of the application, whatever the final outcome of the action. It is possible that a party can be successful in an interlocutory application, but lose at the end of the suit. So when the award is costs in any event, it means that even if that party loses the final case, is still entitled to those costs in the interlocutor application. I don't know whether you have seen an order where the judge awards as costs thrown away. The order requires a party whose conduct has resulted in the proceedings or any part of them being ineffective to pay the wasted costs. For example, a party whose application to amend a pleading is made at the undue late stage in the trial may be ordered to bear the costs thrown away by making the application. You could actually be successful in that application, but you'd still be ordered to pay the costs. In very rare circumstances, the judge can also order that the costs be reserved. The effect of this order is similar to the costs in the cause, except that it enables the court to order otherwise at a later stage in light of the conduct of either party. So the judge has this discretion for the costs to be reserved and determine whether they should be awarded to you at the end of the case. The other common order is no orders to costs. Here, neither party can claim the costs of the application, whether he or she becomes entitled to the general costs in action. No orders to costs is appropriate where the conduct of both parties is considered unreasonable, or in the context, say, of matters involving, say, relatives, like is commonly in the family division. We order no orders, we give no orders to costs to promote reconciliation. Okay. Now, the taxation process is commenced by lodging at the court registry or by ICMIS a bill of costs together with such supporting documents that may be required. For the successful party to prove their expenses, the manner of presenting a bill of costs for taxation is prescribed by the rules, the Advocates' Remuneration and Taxation of Costs Regulations. There is a format on how a bill of costs should be presented before you. If you look at Regulation 47, it will give you that format. So it is very possible for council to challenge the form the bill of costs is brought before you. Now, on every taxation, the taxing officer may allow such a costs, charges, and expenses as are authorized and appear to him, her, to have been necessary to prove for the attainment of justice or defending the rights of any party. The taxing officer shall be guided by the 6th schedule, the Advocates' Remuneration and Taxation of Costs. We have an amendment, Regulations of 2018. And that's where the mathematics applies. Now, with regard to election petitions, if you look at Regulation 6, it provides for election petitions. And it provides that for instructions to present or oppose an election petition, the fee shall be as the taxing officer considers reasonable, taking into consideration the nature, importance, complexity, and novelty of the petition, the place and circumstances in which work or part of it was done, the time expended, the public interest, and all other relevant circumstances. But the fee shall not be less than 5 million shillings for petitions under the Local Government Act, and shall not be less than 10 million shillings for petitions under the Parliamentary Elections Act. So the law has provided a minimum. I usually, when I used to be a registrar, I would casually ask advocates how much instruction fees they would take in such a petitions. They would not know what I'm aiming at, but I would want to know what a reasonable advocate would charge to guide me as a taxing officer. By then, this rule was not available to guide, but now it's available. It's saying the minimum should be 10. But at the same time, the rule is saying you'll consider other things like the importance and complexity of the matter. How does a registrar appreciate that the matter is complex when you have not handled it or you've not had it at all? My view is that you cannot be convinced at taxation that the matter was complex for you to give an unreasonable figure. By these regulations. And I can assure you, if you asked counsel, I don't want to speculate, like Jude Biawakama, what he would charge for an election petition. Most of them will tell you between the range of 10 million and 20 million shillings. That is usually the range. 20 million shillings is the salary of a judge, so for one to earn it in one case, I think, is reasonable. But but for you to award 50 million shillings, what would be the justification? That's where somebody can read into your award. You are guided that the minimum figure is 10 million shillings, but for you, without even the guidance of the judge, because it has to be the judge to determine that the matter is complex. And the advocates must apply to the judge to appreciate that fact, that the matter was complex, and therefore they need a higher instruction fee than would have reasonably been given. So in the absence of those instructions, in my view, a range of 10 to 20 million shillings is what should be awarded in an election petition within these times. These figures can change over time, and that's why at times precedents of the past may not be that helpful, because they could be caught up with inflation. It will be unreasonable for a registrar to quote a matter in 2016 as to what guided the registrar then to award, because 10 years is a long time. Inflation has come in, and therefore it would not be right to quote such a precedence. So at least you are guided. In Local Government Act matters, they say not less than 5 million shillings. If you look at Regulation 7 of the said schedule, it provides for judicial review, and the fee shall be a sum as the taxing officer considers reasonable, taking into consideration the nature, importance, complexity, novelty of the matter, but the fee shall not be less than 3 million shillings. For instructions to sue or defend in any case not provided for in this schedule, the fee shall be reasonable, but shall not be less than 2 million shillings. And the instructions to oppose interlocutory applications shall not be less than 300,000 shillings. So, these rules are just providing you with guidance on what you should award in an ideal application, in an ideal case, where complexity is not pleaded. Now, where due to the complexity of a case, a higher fee is considered appropriate, the advocate for either party may apply to the presiding judge, as the case may be, for a certificate allowing him or her to claim a higher fee. In the old rules, the judge would specify the fraction or percentage by which the instruction fees would be increased. I think that provision was removed in the amendment. But that was the guidance then, that the judge would provide the fraction or percentage by which the instruction fees should be increased. Now it's left to the discretion of the taxing master. No cost shall be allowed which appear to the taxing officer to have been incurred or increased through overcaution, negligence, mistake, or payment by special charges or expenses to witnesses or other persons, or by unusual expenses. In your bill, of course, you have to be very careful of what is being charged. Those up country will be receiving teams from Kampala, I can assure you. It's during this time, if you are working in Arua, or Moroto, or Kabale, it's during this period that you'll see teams from Kampala. Because somehow these losers believe that the lawyers in Kampala are more brighter than those up country to defend these petitions. So they can come up with outrageous expenses. They will claim to have stayed in the best hotel within that locality. If you are in Arua, for example, they might even say they came by airplane. Their witnesses all came by airplane, and they might have even receipts attached. The teams were 10, and they want that costs to cover them. Now, this is what this rule is providing for. Through overcaution, you have instructed 5 advocates, 10 advocates, because you are determined to win. The bill of costs should reflect fees for 1, unless you get a certificate from the judge for 2. That was the petitioner's problem, to instruct so many advocates. You are paying. Somebody might produce a receipt that I paid my lawyer 50 million shillings as instruction fees. Is that evidence sufficient for you to be swayed? When there's a statutory provision on what should be guiding you? So if you're mistaken by the demands by your lawyer, that should not be passed on to the losing litigant. You still have the discretion to tax that item accordingly, guided by these regulations. Hotel expenses. Why should you stay in a hotel that charges 2 million shillings when you could actually be comfortable in one that charges 500,000 shillings? Within the same locality. Why should you choose? So those are the things you should interrogate when taxing the bill of costs. You'd say a reasonable advocate would be staying in such a hotel. If a judge is going out on a session, he's paid 300,000 shillings for a night. And to those the allowances paid. Make these comparisons. So what entitles you to stay in a hotel of 2 million shillings and you believe that should be recoverable? So, the area of expense is actually within your discretion. 1, there are items that can be proved, but there are those which cannot be proved. You are not going to insist on every disbursement for a receipt, because at times that cannot be attained. People who travel in taxis are not issued with receipts. I think you take judicial notice of that aspect. If you go in a Kamunye and you reach your destination and you ask the conductor for a receipt, you can actually earn a slap if you are not so careful. So there are items which you cannot prove, but you use your discretion to award what is reasonable in the circumstances. Now, as a general principle, a taxing officer must consider the following principle: that costs should not be allowed to rise to such a level as to confine access to the courts to the wealthy. The successful litigant ought to be fairly reimbursed for the costs he has had to incur. There was that other one. I don't know whether if this is still the motivation, that the general level of remuneration of advocates must be such as to attract recruits to the profession. I don't know whether we still need recruits to this profession, because I think we are saturated. And as far as practical, there should be consistency in awards made. That's why, as registrars, I think you have a forum. We don't want to start classifying registrars that Waninda, if your bill of costs goes to Waninda, this is what you expect. If your bill of costs goes to any other, this is what to expect. So there must be some consistency, and you must discuss these things on your forum. So as I've said, 10 to 20 is a good range as far as I'm concerned for instruction fees. Now, it was held in that case, Mwogeza Dembe versus Gagawala Wambuzi, that there's a dimension to election petitions. The quest for better conduct of elections in the future, that keeping quiet over weaknesses in the electoral process for fear of heavy penalties by way of costs in the event of losing a petition would serve to undermine the very foundation and spirit of good governance. Your worships, if you add these costs and people now detect the trend that, you know, losing a election petition would amount to paying 200 million shillings or more, losers will stop petitioning court for fear of paying these costs. So you have a role to really promoting good governance by making access to justice affordable to the parties. Cost more than one advocate. I think the previous speaker talked about this. This is not a matter that should be argued before you when a party is presenting a bill of costs. It's a matter for the trial judge to determine whether to award costs to 2 or 3 counsel. But it should not be an argument before you. Your hands are tied. How about a litigant who changes advocates? As it often happens in some of these election petitions. If somebody came to you and said, I instructed 3 counsel at different intervals, what would you do as a registrar? Where a successful party's full bill of costs includes instruction fees was filed by an advocate who had not done the preliminary work, but only came on record at a very later stage when he or she was instructed merely to tax costs. It has been held that this advocate was not entitled to the costs for the works done by the other advocate who was on record. Items should have been claimed by the previous advocate. Items that should have been claimed by the previous advocate must be listed separately on a separate bill and must be made an annexure to the bill of costs of the current advocate. And then the current advocate should explain to the taxing officer what costs are due to him or her and those that are due to the previous advocate. In my view, therefore, your change of numerous advocates should not be visited on the losing party. The instruction fee should be the same, and whatever disbursements should be itemized and annexed by the latest council. Otherwise, you run a risk of awarding the petitioner costs for 3 council when those costs were not ordered for. And this is bound to happen. You'll find litigants who will be changing counsel all the time. So you must be very careful when taxing these bills. Now, there could be some contentious matters. And in these days when people are appointed on active basis, they want to be extremely careful. Because the way you tax a bill of costs actually could determine whether you'll be confirmed or not. That one I can assure you. So, the safety net for any registrar, even in any other matter, by the way, even in any other matter, I know you handle now so many applications that usually were handled by judges, but some of them could be very, very, very contentious. As a registrar, you have a safety net. You have other shock absorbers, you know, that you could use to cushion against being victimized easily. And I find Rule 50, Order 50, Rule 7 handy. If any matter appears to the registrar to be proper for the decision of the High Court, the registrar may refer the matter to the High Court, and the judge of the High Court may either dispose of the matter or refer it back to the registrar with such directions as he or she may think fit. So even if you believe you have the jurisdiction in any matter, but you believe you are not comfortable, let me use that plain word, in handling that matter because of the ramifications, you could refer that matter by way of reference to the judge. If it's about, say, contention in instruction fees, you could actually refer that item to the judge for determination or guidance. I think that is also available in those regulations as I've cited. The parties may also consent to make a reference in writing to the judge on certain items they feel are contentious. And your role is just to forward that. Now, in conclusion, just be mindful that the politicians who appear in court to contest the elections have already incurred a lot of costs and expenses. They have lost a lot of money in campaigns. They actually broke at that stage, and they are borrowing from money lenders. That is a fact. By the time they come to court, they're actually now borrowing from money lenders, because even the banks, they have loans. The banks cannot advance them with loans. But being a matter of life and death, they will fight until the last, especially if they believe they actually have been successful but cheated in an election. So they should not be subjected to unreasonable costs. In my view, their cases should be viewed as public interest cases because so many people have interest in the outcome of such petitions. And exorbitant costs would bar future litigants to shun the courts due to the anticipated exorbitant costs they would have to incur in the event of losing their petitions, which would be a very big detriment to our democracy. So I want to believe you now appreciate your role as registrars, and I want to leave it at that and rest my case.
Thank you so much, my Lord, for those insights and breaking down the law for us. As we go to my brother Jude, my Lord, you'll talk to us about we hear certificate of two council, right? Is it for all the items? Is it for item 1? And if it's for item 1, do you tax the whole bill and increase it by 1/2, or only item 1? That will be your first question when you come back. Let's listen to Jude.
I mentioned that under the old rules, there was a provision that if certificate was given to two council, there were 2 ways. The bill, of course, would either be increased by half, the entire bill, or the judge would consider a percentage on which the bill would be increased. But the new amendment has no such a provision. So in my view, if a certificate has been awarded to, because the reason I think they removed that item was to leave the bill to be, I mean, the entire bill should reflect as if it's for two council. Because there is no way, I think the rationale was, if you have been two advocates in an area, and you have been staying in the same hotel, for example, that charges $100, why would you want this other advocate to get half of that reimbursement? Okay. So my view now is that if it's certificate for two council, they are entitled to even instruction fees and the same amount of costs. That's my understanding. I know this is something that has not gone on appeal, but my reading into the amendment implies that that was the intention. Otherwise, I think they would have left that provision that gave discretion to the judge to either increase or to by a half or by a percentage.
Thank you, my lord. Let's welcome Advocate Biamukama.
Thank you, Your Worship Faizo. I can see it's almost 4:30, but don't worry, it's a very brief presentation. Some of the issues were repetitive, so I will just gloss over them and give you the perspective from the bar. When we are presenting bills of costs for taxation, or when we are opposing bills, what we have in mind. For me, initially, what attracted me to actually specializing in election matters initially was that I used to see the taxed bills of costs around 2006, and they were awarding 200 million. So by the time I was almost completing LDC, I knew I needed to learn how to prosecute election matters, among others. But over the course of time, I've been a bit frustrated. I think I have prosecuted one of the highest numbers of election petitions, both from the perspective of filing petitions and also opposing petitions within the last 10 years. But that having been said, these principles cut across. There are times when they are good, there are times when they are good, there are times when they are not so good. Now, the general principles, I'm not going to go through them anymore. The general principles for taxation of costs, I know you are familiar with them, but just to remind ourselves, there are those key principles from the Makumbi decision. I will focus more on election matters. So, when it comes to election matters, the key principles to remember, some are spelled out in the judgment of His Lordship Justice Kenneth Kakuru of good memory, Lanyero Sarah and the Electoral Commission versus Lanyero Mori, that's Court of Appeal. Among the key things to remember, an election petition and an election appeal differ in a fundamental way from ordinary suits and ordinary civil appeals. That's why you see the regulations also now give a minimum of 5 million for a local government petition, 10 million for a parliamentary election petition. And the other principle is that parties put in a lot of time and industry in preparation of petitions and are entitled to commensurate remuneration. I have heard my lord saying 10 million should be fair enough. That's already almost half the salary of a high court judge. But the truth of the matter is, if I can be very frank, I think the very last petition I prosecuted was in the High Court at Soroti less than 3 years ago, arising out of a by-election that was conducted for the constituency of Soroti City East. I think just preparing the petition and filing it before it could be heard cost around 18 million shillings. The petition had around 90 affidavits, because by its very nature, you have these petitions where you need many witnesses because of the nature of the petition. In that petition, my client was challenging 5 polling stations which had 100% turn up with 100% votes cast in favor of one candidate. And the affidavits were from witnesses who were saying, on that day I didn't vote, I had gone for value, on that date I was in Kampala, on that date I was in Jinja, because we wanted to impeach the results at those polling stations. Now, what did that mean? First of all, it means that you have to first go to Soroti to interview these people. So you have a team on the ground probably for a week, interview them. Then there are issues of language barrier. You need an interpreter yourself to be able to understand. And that exercise takes time. So you have probably 2 advocates, you have an interpreter, and they camp in this area for a full week for you to get those 80 affidavits. And then, if you are to have a petition heard when your witnesses have not been stolen or compromised, sometimes you find that key witnesses, you need to provide for them separately, especially those like 2 weeks before trial. You find that you need to hide them, meaning you need to get for them a hotel, book them there, and keep them for a full 2 weeks. It's part of what you do by the time. Otherwise, if you keep quiet and think things are okay, by the time you go for trial, you'll have no witnesses. So there are those expenses which are hard to justify at taxation, but sometimes they are part of why, when we say it is hard work to prepare a petition, it can indeed be quite expensive to have a well-prosecuted petition. And there are those simple petitions. Petitions are not the same. I did one in respect of a constituency in Chisoro district. The dispute was simply about a void ballot paper. The ballot paper did not have the correct names of all the candidates. I think during printing there was an error, and the printer instead picked names of candidates from a completely different constituency in Bushenyi and put them on a ballot paper in Chisoro. And so prosecuting that, the Electoral Commission was very kind. In their answer to the petition, they conceded that indeed the ballot paper had this error. Only that their approach was, the party symbols were correct, the pictures of the candidates were correct, and each presiding officer sensitized the voters at each polling station to disregard the wrong names and focus on the symbols and picture. And of course, they also argued that, well, most voters in that area are even illiterate. What would they need the names for? So such a petition was not complicated. I think I only had 6 affidavits. It's the Electoral Commission which had, I think, over 60 affidavits, because they put an affidavit of each presiding officer at each polling station to confirm their desensitized voters. So that was not extreme. I don't think I spent more than 7 million preparing that petition. And by the way, it was allowed by the Court of Appeal. So there are petitions like that. But there are also those ones really which work you, which are quite involving. So it's important to have that mix. So that principle that parties put a lot of time and industry in the preparation of petitions and are entitled to commensurate remuneration has to be taken into account. There are those petitions which are demanding. There are those academic qualification. Either someone's nomination or a nomination paper has an error. You don't even need many witnesses. There are those kinds of petitions. And therefore it is good to have a look at the judgment as well. And then there is no specific value in respect of the subject matter. However, a person who loses an election petition should not be solely and personally punished by being condemned to pay excessive costs. Again, this principle is important, and you'll see it cuts across. that if costs are excessive, they will have a chilling effect on persons present and future who may want to stand for elective office, and therefore political ambitions should not be unjustly frustrated, since petitions play a key role in fostering electoral democracy. Now, when petitions are being filed, people file them for different reasons, but the majority of petitions, people actually have genuine grievances. That many petitions don't succeed does not mean that there are no grievances. I think in 2021 cycle, just only 7 or 8 petitions were allowed, the entire country, out of over 130. But it doesn't mean those which were dismissed had no grievances. In fact, I remember in 2021, out of those 7, actually 3 were mine that were successful. But there's a petition which even the Court of Appeal, I succeeded with my client at the High Court, and the Court of Appeal reversed and set aside the judgment of the High Court. But even their lordships at the Court of Appeal felt that despite failure of this petition not succeeding, the Electoral Commission needed to reimburse costs of my client who had lost the petition, and ordered the Electoral Commission to pay 2/3 of my client's taxed costs, both for the Court of Appeal and the High Court. So there are cases like that. And that brings me to the other issue. Excessive costs against individuals should generally be avoided. But should that also apply to the Electoral Commission? Is it an individual? So you'll find that, I'll point out some of the taxations. But a taxation against Electoral Commission, yes, that's taxpayers' money, so it's still money belonging to a collective of individuals. But at least the Electoral Commission is not going to be hounded. The problem that we usually see is, if a bill is taxed against an individual, and then tomorrow you hear this individual has been committed to civil prison. I remember I had a very unpleasant experience in a recent petition. My client was successful. Unfortunately, I had only represented him in the Court of Appeal and not in the High Court. So, first of all, I could tell, I had interacted with my client, and I knew that the judgment data was his guardian. These people were fighting for an MP seat, but they actually had a history. In fact, his guardian had even paid for him education for a law degree. But they were fighting for the same seat. He went to High Court, he lost. He came to me on appeal. We won the petition, and the Court of Appeal ordered a by-election. A bill was filed and taxed against the Electoral Commission, around probably 40-50 million. The Electoral Commission paid. Then when it came to a bill against his guardian, I told him, but Honorable, I'm not comfortable. In a good conscience, I'm not keen on even taxing this bill. And he said, no, you must file it and tax it, I paid you. So under duress, I filed it, and it was taxed and allowed at around 18 million. Because of course I filed it knowing that I have no interest. This is an individual, a guardian of my client. Then to my shock, I later learned, I got phone calls later from Parliament that, hey, Council, this tax bill, why don't you reduce it? And I said, which one? You mean 18 million? They said, no, we have a bill here of 150 million. They said, which one is that? Only to discover it was a tax bill from the lower court, which I had no control over. Of course, I wondered how a bill of 150 million had moved. And there was a challenge. Some of these politicians, they may appear to be educated, but as all of you have better experience than I do, many educated people don't understand even the procedures in our courts of law. So I discovered that this judgment data had actually entered a consent for that tax bill before the registrar in High Court of 150 million. And so he came to the Court of Appeal. He appeared in an application trying to get a stay before Justice Godantene, and the judge asked, do you have a problem with the tax bill in this court or the lower court? Then he said, in this court, my lord, I have no problem. Then he said, what about in the lower court? He said, I consented to the bill. So the judge said, so what do you want me to do for you? It was you who consented. He ended up in civil prison, by the way. But I think as taxing officers, even where you see that parties are trying to consent to an arrangement, which on the face of it is unconscionable, I think you should step in and not permit it. because indeed, petitions should not be used to penalize anyone in the costs. I could see here people were basically fighting. It's like, yeah, even our families don't talk and all. You see, there is that anger which people have. Because my client, after we got for him a nullification, they went for the by-election. He still lost the by-election. So, of course, he was also very angry. And therefore, for him, this was a continuation. And usually, you will discover that many parties tend to tax these bills close to the next electoral cycle, so that they can use them to negotiate and say, okay, I can tax this bill and we shall pursue you, but if you agree that you are not standing, yeah, we can ignore it. But now that is an anti-democratic move, and that is why individuals, as much as possible, should be protected from excessive bills. And then obviously, there also, when we talk about the interest of parties and the public, the value addition to national jurisprudence, there are those petitions which, even if they don't succeed, they have value. That is why you see the Supreme Court has, in 4 different petitions, declined to make any order on costs. When we prosecuted the presidential petition for JPAM against the president, it was unanimously dismissed. But it made recommendations which ultimately compared an amendment to our electoral laws. So it had some value. The petition wasn't completely useless. It wasn't abusing court process. And therefore, that is important, even if an order on costs has been made. In fact, for me, I remember in one petition which was dismissed with the cost at the High Court, the one involving a void ballot paper, I raised the ground of appeal precisely on that complaint. My argument was, why would you condemn my client to costs? Yet he clearly had an arguable point about whether this ballot paper was void or not. And indeed, the Court of Appeal allowed that point and said it was in error for the trial judge to have awarded costs where there is such a serious complaint that is admitted, and the only issue is what the law says about it. And therefore, even if the court has awarded costs, it's important to be mindful that awarded costs shouldn't amount to an injustice to one party. They should not frustrate candidates. They should not deter the public from seeking elective office or filing petition or seeking redress when supposedly cheated in elections by an award of exorbitant costs. And elective offices should not be a preserve for the rich. Legal costs should not be used as a weapon against political opponents. And most importantly, high legal costs in election petitions can have the effect of reversing affirmative action for marginalized groups such as women, youth, and persons with a disability. When people hear that someone lost an election petition and is paying 90 million, someone has never touched 5 million in their life, 2 million in their life, and they hear they have to find 90 million. Of course, they will, if they stand, they know they will never be able to file a petition. But again, someone is going to say, why should I stand and be cheated, supposedly, and then just abandon the exercise? It's meaningless. And so that's why these costs should be kept reasonable. For me, who has represented both petitioners and respondents, I can see for sure that a number of litigants who are common in this area of election matters, some of them eventually become the MPs. I've seen like 2 or 3 who started fighting, who would, every time they would lose a petition, they lose a petition. And the next time you see, they are now the ones who are elected. Meaning sometimes probably even the public and the voters have a view about them. So it's important for high legal costs not to be imposed because they could discourage numerous marginalized groups from participating in these kinds of matters. And therefore, let's quickly look at a few tax bills that have been reduced. I think from that list of 6, the most current would be number 3, Mugisha Vincent versus Aston Kajara. I think that's a 2025 ruling, where a tax bill was reduced from 40 M to 30 million. Then Mukesh Shukra versus Senyonyi Joel. Again, that's a 23. A taxed bill from 50M was reduced to 30 million, and then taxed bills for applications from 5 million to 1 million. That was the instruction fee on an application. But again, the subject matter, it's important to remember what the subject matter in these petitions is. Because I think this petition was quite basic. So 30M was quite reasonable. And then there are those other old petitions. You can see Dr. Ismat Abraham versus Dr. Epetite Francis. I think that was around 2011. It was reduced from 140 million to 64 million. Brenda Nabo Kenya Rebecca Naranga, 120 million to 25 million. And then Abdul Katunti is also quite old, 60 million to 25 million. So you can see the range. There are those which could be around 60 million. Like I said, I see most rulings, if it is electoral commission paying, it's a bit different from when it is a private individual. That's a distinction that must be borne in mind. A few procedural issues as I conclude. First of all, council-to-council pre-taxation is mandatory. You will notice, your worships, that when you can also guide the advocates. For me, I don't think I've had any contentious bill of costs where we go into references and all for the last 10 years. But because sometimes we try to reach out and agree. In this day and age, I don't see why court should be taxing any other item apart from the instruction fee. People should be able to agree. This 100,000, 50,000. Those are things which, if you force the advocates to agree, they will definitely agree. But if you tell them you're ready to tax and waste your time with them, taxing a bill with 70 items and only 30 makes sense, you simply create unnecessary work. They should be able to agree. From my experience, it's only the instruction fee, where parties may need intervention of court. And then obviously, there was a slight comment already, separate bills of costs. When a petition succeeds, and there is electoral commission, and there is a candidate, typically, we separate the bills of costs from the petitioner's point of view. Some respondents don't like this. But you see, if court has ordered the costs of the petition, and there are two respondents, electoral commission and a private individual, if you combine them and it is taxed, who will pay what? Will you say equally, is that the principle that they will share it? Because you see, when you're prosecuting a case against electoral commission, as opposed to against an individual, there are expenses which electoral commission may create. For example, obtaining certified DR forms. The expenses on that bill, surely, should another candidate also contribute to that bill if court has said the petitioner should be reimbursed? So usually it is more practical to separate them. That's from a petitioner's point of view. Some respondents may not agree, but I think the principle requires to separate them. But a returning officer and electoral commission, those are the same. You can't have a taxed bill against a returning officer and then a taxed bill against the electoral commission, because the returning officer is an employee of electoral commission. But a candidate is separate from electoral commission. Then also, if a petition has succeeded because a candidate committed an electoral offense, should the EC be footing that bill? At times when judgments are made by the court, they may not be very careful on the issue of costs, on how to allocate them. Sometimes a judgment simply says the appeal is allowed with the costs. And then you have electoral commission is haggling with the candidate. The electoral commission is saying, no, this petition is succeeded because of voter bribery committed by the candidate. Why should we pay this bill? So in those cases, that's why it's also necessary to separate the bills so that it's easier to apply the principle. Sometimes there will be debates about extracting of the decrees. Some decrees can be confusing. If they involve fractions, 2/3, a third of this. I remember that decree which we had over a matter that the Court of Appeal ordered my client to be reimbursed, although he lost the appeal. I think the registrar took a month to agree, thought there was an error, or we were tricking him on how the order should be. So it's important to also guide parties and be involved in extracting a decree. Some parties would not be very cooperative naturally. The same with the service of bills and taxation notices. A party who wants to pay will always be uncooperative. And that should also be adjusted. And then this issue was already hinted on by my Lord Justice Boniface Wamara, issuing warrants of arrest to recover taxed costs. Again, this should be approached judiciously. There's a time I saw a matter where the main appeal was pending in the Court of Appeal, but the lower court issued a warrant of arrest against the appellant. And by good fortune, the Court of Appeal actually allowed the appeal with the costs. So it can create a bit of an issue. As already guided, although the law doesn't say an appeal is a stay, in election matters especially, it's very important to be prudent and avoid issuing warrants. This is a political contest. You will get caught up in it, and people start saying, no. The registrar is a supporter of X or Y. That's why warrants of arrest are being issued when there's a pending appeal. So it's important to be mindful about the context, the timing, exhaustion of other options, whether there have been demands for payment and have not been made. And that's why, therefore, we conclude with the saying, it's a good practice that execution of costs shouldn't take place if there's a pending appeal on the substantive decision of the High Court, or if there is a reference to the judge, even though there is no stay. Because if you keep forcing parties to apply for stay, you are inviting a multiplicity of proceedings in your court. That any time, if parties learn that her worship will always issue a warrant if there is no stay, it means every time you tax a bill, you'll always have an application for stay pending before you. How do you avoid that? Administratively guide the parties and say, okay, there is a reference or there is appeal in a higher court. Let's be patient. Once the appeal is done with, I will proceed with execution. I thank you very much.
Yes, thank you so much. Colleagues, I invite you to give Mr. Byamukame a befitting. Yes, our time is fast spent. I know this is going to be our food, but we are going to take only 5 questions. The Chair Governing Council is in the room, and he's already been here for more than an hour. So let's take only 5 questions. We take the slots, then we know who will ask. Okay, from the gallery we have 2 people only, so we shall take their, 3. Okay, we shall start with my sister Nusra.
Thank you so much, my Lord. Thank you so much, Council Byabakama. We truly appreciate. I'm just wondering if we have numerous lawyers at numerous stages of the petition, and they agree to filing a joint bill. Should I reject that as the registrar and insist on filing separate bills, or one can suffice? Thank you, my Lord.
Thank you, my Lord, Justice Katirima, for taking us through Schedule 6 and other legislation relevant. Thank you, Council Judy, for that comments and presentations. This is to both Justice Katirima and Council Judy. My Lord, while you were presenting, you properly and rightly said that some of these petitions are intended to promote good governance. In some instances, some of us, we think the parties are bringing electoral commission to court for auditing the electoral processes, that there was rigging here, there was mismanagement here, there are ABCD here. So it is more of an audit of was this exercise genuine or not. Now, at the end of the hearing of the petition, like Councillor Judy said, out of 130, 123 dismissed with the costs to be paid to the respondents. One of the respondents is Electoral Commission. We know very well We know very well that Electoral Commission draws its budget from government. And this budget is resourced by the taxpayers. This litigant is one of the taxpayers, including he even brings to court non-tax revenue, NTR, at filing. Now, this Electoral Commission, when it is electoral season like now, they present a supplementary budget. In that budget, one of the items is to conduct a free and fair elections. Part of another budget within that is to outsource lawyers to come and beef up their legal department. And that budget is resourced. Those lawyers compete by putting in their bids, and they are paid to go and help Electoral Commission to defend this audit process. I'm calling it an audit process, to defend the audit process. Now, when the case is dismissed with costs to the respondents, Electoral Commission brings a bill against this person who pays taxes, who has also paid another non-tax revenue for a second time as court fees, who has also deposited a security in court. And now Electoral Commission wants this person also to pay them costs which were already budgeted, disbursed, and utilized, including the money, the nanny wage which is given to Electoral Commission. Is it time?
Yes, continue, but try to summarize the question.
My question is, my Lord, as judges, do you find these bills by Electoral Commission legitimate bills? Are we really, when we award them costs, are we not affecting good governance? So, how do we balance that this taxpayer who has paid taxes 3 times should not be inconvenienced by coming to our system to check whether the process was free and fair and whether it promotes democracy or not? Thank you so much.
You didn't talk about where the court orders that each party bears its own costs. I have seen situations of where lawyers now are filing bills against their clients because court ordered, all parties agreed that each party bears its own costs. Is that proper? Then, in situations where an appeal has been filed in the Court of Appeal, but the bill of course has been filed also, should we go ahead and tax the bill, or should we wait the outcome of the Court of Appeal? Thank you.
Okay, when they say each party should bear their own costs, and you have instructed counsel, you have an obligation to pay counsel. Your counsel instructed. The counsel will not have done the work pro bono. Okay? In other words, they are saying you are not going to recover these costs, but you have an obligation as a client to pay your advocate. And that's why you have those advocate-client bill of costs. So there is no, if the court says with no orders to costs, it means costs paid to the other party. But your obligation as a party to your advocate is to pay him his fees or her fees. You cannot be exonerated from that. Secondly, in my view, there's nothing that would stop you from taxing the bill. What you should not do is to rush to execute until the bill is, until the appeal is what? Is decided. In my view, I think there's nothing that would stop you, because you have no stay before you, and you can't say, I will await taxing this bill until the Court of Appeal makes a decision. Get that file out of your way. If the decision is overturned, well and good, but don't wait for that time. You only wait when the execution process is due. EC management of electoral processes, would it be right to condemn EC in costs? There are people who will just file suits for the sake of it. they call them bogus suits. Why shouldn't this person be condemned in costs? Otherwise, it would attract busybodies to file anything. So yes, it is promoting good governance, but the court should also assess whether you have really brought a bogus petition. You've lost, for example, I'm going to give an example. You've had an outcome in an election where you have 300 votes and the winner has 20,000 votes, for example. And you want to challenge that. Of course, it is possible that somebody could have got 20,000 votes out of rigging and what have you. But if you don't have any iota of evidence, for example, why shouldn't you be condemned in costs? You have wasted taxpayers' money, by the way, by bringing the EC to court and incurring expenses in the process. So the signal should also be sent that, yes, much as we allow access to justice, but you should not be at liberty to bring bogus petitions, and therefore you can equally be condemned to costs. Numerous separate bill of costs? No. Whether the firm has brought 10 advocates, they are not at liberty to file 10 bill of costs. The bill of costs should reflect one advocate. So, they are not at liberty at all. The firm can only file one bill of costs, and the costs will reflect as if it is one advocate, despite the number of advocates that may have appeared, unless the court allows certificate for two counsel. If the court allows certificate, say, for two counsel, that's when you can now have maybe the two bills. But whether you have brought 20 or whether you have brought 50 or if you are successful and there is no award the same applies, in my view, if you have instructed even 3 firms to represent you and you have not got a certificate of two counsel, you are not entitled to those costs. It will be only one person, one advocate entitled to the bill, despite you having instructed 5 or 10, unless the certificate is issued by the court for two counsel. And in very rare circumstances, I think it's even unprecedented. I have never seen a court award certificate to 3 counsel. Maybe it has happened. The maximum they usually give is 2. Yeah.
The current case law holds that no instruction fees can be awarded to Electoral Commission or any government body generally. For the very reason that the lawyers who prosecute matters on behalf of government bodies, that is either if it's Attorney General's chambers or a legal department of an institution, are salaried lawyers, and therefore it is not proper to award an instruction fee. It's case law, really. It's case law. Unfortunately, I didn't. This was an area I think we should have addressed. But there are around 3 decisions around that very point.
Yes. Well, I will share an authority later where the court says that those that come through PPDA, they've already been pre-qualified. They are enlisted as service providers for the government, and their services are charged at from the consolidated fund. They are under retainer by Electoral Commission. They are not entitled to costs from the court. And if you order that the costs be paid, then you order that they be paid in the consolidated fund, not to their respective individual accounts. Okay, you've been such a great audience. Let's put our hands together and thank the presenters. Want to thank you so much for allowing us to tap into your pot of wisdom. We go away well nourished, and we shall undertake to perform better.
Lord, the Chair Governing Council, we want to thank you so much for the calm and firm leadership that you give to us. It is because of your leadership that we have been able to achieve what we have been able to achieve within this short very period of time, as you know. But in a special way, my Lord, I want to thank Her Worship Lillian and the JTI team. These people have really, I don't know which words to use. My Lord, I think within the last 1 week or so, they have been doing a lot of heavy lifting. You can imagine organizing a training for the Supreme Court and having 98% attendance of the court. And they deliver the training, my Lord, without any hitches at all. Shortly after that, they came and delivered the annual Magistrates and Registrars, annual Registrars and Magistrates Conference, alongside the training for High Court judges on the handling of election petitions. All these were 2-day activities, but they did that very well, and they've been able to also organize this particular training amidst many activities that they have done since May to the end of the year. So Your Worship Lillian and your team at JTI, we appreciate you. Thank you so much. My Lord, Chair Governing Council, we shall commit to adhere to the training calendar that you and the Chief Justice and PJ and the Honorable Attorney General officiated here last week. Things have been a bit tight in terms of doing ad hoc. In the series of meetings that we have had with you, you have emphasized adherence to the training calendar. And that, my Lord, is something that we shall not negotiate, save for exceptional circumstances that you as Chair Governing Council will approve. My Lord, in a special, I want to thank Justice Keitirima, Justice Wamala. These 2 judges have been, I don't know which word to use, but simply put, a call away. I talked to Justice Keitirima, I think 48 hours ago. The same to Justice Wamala, we engaged him, and they committed to be available. And as you know, this particular season is a very, very demanding season. So we really appreciate you, my Lord Justice Keitirima. We appreciate you, my Lord Justice Wamala, and we appreciate you, my brother Jude. Chair, we also appreciate you for coming to grace the official closing of this ceremony. The session chairs, His Worship Zirintusa, His Worship Faizo, and all the worship that have been here making presentations and facilitating this conversation. And lastly, we thank their worships. And my Lord Chair Governing Council, I would request that you lead the clapping for their worships, and then the rest of us will join in. My Lord, with those few remarks, I now invite you to make your remarks, my Lord.
Thank you very much, Executive Director JTI, Professor Justice Hauha. Your Lordships, the facilitators, Justice Keitirima and Wamala, distinguished faculty from the bar, Counsel Jude Biamukama, Your Worships, the Registrars, special mention of the Registrars at JTI. Ladies and gentlemen, good afternoon. I will begin by sharing what I've always shared at many training sessions, and in case you have heard of it before, forgive the repetition, but I repeat it because it captures the mood, and the essence is about the fact that many lawyers especially and court users complain that when judicial officers come for training, they create more backlog. You are leaving backlog. Now, instead of handling backlog, you are coming for training and creating more backlog. But the example I heard about, which I always give, is about two men given access to cut down 2 mvule trees. Those from Semeika Kunguru territory, you know mvule trees very well. So one of the gentlemen started cutting straight away with zeal, enthusiasm, and a lot of energy. The second looked at the axe and asked for a sharpener, whatever they call that thing that sharpens axes, and first sharpened the axe. And then he started about 30 minutes late, but in any case, in another 15 minutes, the tree was down. His friend who had started with vigor, energy, without sharpening the axe, was still working at it an hour later. And that captures why we need to come and sharpen our axes, so that when we go back, it doesn't take us as long. I asked the ED to read my remarks this morning because I was 15 minutes late and I didn't want to keep him and the principal judge and the rest of you waiting. Usually I'm a stickler for time, so when I knew I was 15 minutes behind time, I asked and he kindly agreed to read my points. But I want to highlight key points from them. You hold immense responsibility as the quiet guardians of justice, keepers of records, and the backbone of our judicial system. Your role, though behind the scenes, is both significant and apparent, ensuring compliance with statutory timelines, payment of prescribed fees to ensure that indeed they have been paid. And you may have come across instances where petitions were struck out for non-payment or underpayment, and maybe the files passed by the registrar's desk. Of course, there is proper presentation of pleadings and adherence to procedural requirements, and ensuring effective service and accuracy of records. Over the past sessions, we have examined the complexities of electoral disputes, the technical procedures, the time pressures, the logistical demands, and the weight of political scrutiny. However, these challenges are not barriers. They are opportunities, chances to showcase excellence, resilience, and integrity. Every petition whose process you handle, every record you protect, and every procedural step you manage reinforces the foundation of electoral justice. This training was not just about procedures, I hope. It should have been about empowerment. It was about giving you knowledge, confidence, and ethical compass to handle high-pressure situations with clarity and fairness. In case you have not handled election petitions before, this high pressure we are talking about is very real. Very, very high pressure. One of the most high pressure times I faced was when I was handling election petition as a representative of the Constituent Assembly Commission lawyer in an election petition. There were two actually, one in Soroti between the late Atekere Ejal and Kano Maria. These were two heavyweights battling for Soroti municipality, and the pressure was palpable. Mbale municipality between late Honorable James Wapakabulo battling former CJ George Masika. Very, very heavyweight, and I felt the pressure so much. But not just me, every player in that arena had to face pressure, and this is something you have to learn to deal with. You have to learn to stand firm as long as you are on solid ground, and that solid ground is what they have been training you in. Through your engagement, questions, and willingness to share experience, you have shown that the strength of our electoral justice system relies on the competence and dedication of those behind the desks you sit on. I want to thank the JTI, led by the very able Justice Professor Andrew Hauha and his dedicated team of registrars, magistrates, researchers for providing this platform that connects knowledge, experience, and practical skills. Let's take off a minute and give them a hand clap. As the Governing Council, we reaffirm our commitment to support your growth, understanding that a strong registry is the foundation of a credible judiciary and a vibrant democracy. I also want to thank the distinguished facilitators, the Justices Wamala and Keitirima for their dedication, and Council Jude here. If I had time, I would engage you. I've read 2 statements from the Law Society. I wanted to know which one you subscribe to, but this is not the time and the forum for that. But we thank you all for the dedication and the time you spent sharing knowledge with all of you. As you resume your duties, remember that the work you do might not always be in the spotlight. When the papers are writing, they are writing about the judge handling the matter and the lawyers. They may not mention the registrar who has done a lot of the background work and ensured the matter goes smoothly. But you are not working for publicity, but you are working to shape the actual heart of justice. Carry this knowledge and responsibility with a lot of pride. Let your diligence, professionalism, and courage continue to set the standard for excellence in judicial service. It's now my honor to declare this training closed, and I wish you a Merry Christmas and Happy Holidays for God and my country.